Hi everyone. Okay, it looks like we've got the majority of the people joining us in at the moment. Good morning and welcome to the K3 Hub. This is our first accredited CPD session this year, and I'm really glad that you're able to take some time out of your Friday to spend with us. My name is Marie Wadeson. I'm a managing director at the K3 Capital Group, and I also lead the K3 Hub. Ordinarily, at this stage, I will tell you a little bit about the K3 Hub and what we're up to at K3 Capital Group, but I do know that we've got a very full session today with lots of important information to hand over to you. So there is a slide on the screen that's going to give you a little bit more information, and I'm going to move on to some housekeeping. As usual, we are recording today's session, and the webinar, along with previous recordings, will be posted on the K3 Hub website, probably the early part of next week, should you wish to look back. Q&A function is open, so do feel free to ask questions as we go. Having spoken with our speaker this morning, preference is that you use the Q&A function rather than the chat if you have got questions to ask. That just helps us keep everything in the same place so Tony knows where to look. We are going to post a PDF of the slides into the chat shortly, and then we'll do that periodically throughout the session for anybody who arrives a little bit later on. We will be taking a couple of breaks on or around the hour because we know this is a long session and lots of information, as I've already said. We're also going to be running some polls today. They are anonymous, so please do get involved, and they are just for fun. Okay, so I'm moving on to introducing our speaker. So I'm delighted to welcome back Toni Trevett, who's spoken for us on many occasions now here at the Hub. Toni is a qualified HR practitioner, mediator, trainer, and coach. She's a fellow of the CIPD, and she also sits part-time to hear cases for the Employment Tribunal Judiciary. So in today's session, Toni will focus on the last 12 months and what's new in employment legislation, the many changes planned for 2026 and beyond, key case law of late that shapes how people and situations are managed legally, and then changes in statutory calculations. Just before I hand over to Toni, just wanted to give you the heads up on a couple of forthcoming CPD sessions for you that you might be interested in. 20th of March, we've got employment and payroll taxes. Invites will be going out for that next week, so do watch your inbox. And also on the 27th of March, we've got a tax issues associated with the different business structures session running. That is extremely popular, so do put your place on that as quickly as you can do. There's a link on the K3 Hub website if you want to register, and there'll be invites going out as well. That's all for me for today. So I'm going to hand you over to Toni to get underway.
Thank you so much. Thank you, Marie. And welcome everybody. As Marie said, we've got a lot to get through today. We've got a 3-hour session and it's a year since the last update. So there's a lot to tell you about. Hopefully the screens are moving. Marie's already very nicely introduced me to you if I haven't met you before. So thank you very much for doing that. I did hear, as Marie said, I sit and hear cases for the Employment Tribunal Service. I sit in South London, and I did hear a solicitor friend of mine recently say that they were trying to get a 3-day case listed, and the tribunal had said the earliest was 2029 for a 3-day hearing. So it is amazingly busy and proper backed up at the moment. The last we heard in our region was that there were 515,000 people waiting for an employment tribunal hearing, and open cases are up 33% on last year. So it's busy, lots of cases and lots of case law as a result of that. So as Marie said, this is our agenda. I won't reread it to you, but there's lots of upcoming employment law changes in 2026. There are significant changes and there's lots coming in 2027 too. And this is all part of the phased rollout of the new Employment Rights Act. So during the session, we'll definitely look at all of that. We'll look at some of the most kind of common and useful employment law cases as well. And we'll look at what's likely to come in next year too. So we've divided the session into these 4 areas. We'll try and have a break every hour. If you have any questions, please load them in the Q&A and I'll try to get to them either during the session or I'll come back to people afterwards. So that's broadly how it will work this morning. I do have a bit of a strange thing going on one of my screens, and it says, please move this window away from this shared application. I don't know what it's talking about, but as long as you can see everything, we'll just ignore it and carry on. If there's any issues, I'm sure someone will let me know. So if you've been on one of my sessions before, you know I love to start with a little look back at a few headline grabbing cases, or at least headlines that grabbed me. And some tribunal cases have the power, I think, to stop people in their tracks and make you wonder if the world has gone balmy finally. But often those cases cast light on everyday kind of workplace issues or moments that people experience, and the events that lead up to them, and the consequences that follow them should litigation be a result. So sometimes it's misjudged jokes and wind-ups to outright, discrimination. So let's start with a couple that stood out for me. This case with the cooperative group was where a warehouse operative with, I think, about 10 years service succeeded in his unfair dismissal claim after he was sacked for making high-pitched Michael Jackson-esque noises at work, among other noises he liked to make. Behaviour which his employer decided constituted gross misconduct. It's a new one on me that someone's noises might lead to their dismissal for gross misconduct. Gross misconduct means no notice. You leave with immediate effect. And the tribunal found in this case multiple flaws during his dismissal process, and that's why they ruled in his favour. So he won, and he was able to prove that he had been unfairly dismissed. The issue central to this case began when his employer did some bullying and harassment training. And at the end of the session, an employee who was referred only as SM reported to the trainer that the claimant had bullied and harassed him. And I do lots of this kind of training annually for many employers who repeatedly, I've worked with a large insurance company, and they train all their staff every year, once a year, on equality, diversity and inclusion. And I do those sessions every year. And it's not uncommon for someone to stay on afterwards, or most of them are webinars these days, raise their hand and say, something has happened to me. Anyway, on this case, that's exactly what happened. And the report was made to the trainer from SM that there were issues in relation to this claimant. And the SM talked about these high-pitched sounds synonymous with Michael Jackson, but worse still said, and he also made monkey-type noises, and that he had felt, upset, bullied for, some considerable amount of time because of the kind of noises this person made. Anyway, he decided to raise it only because another colleague had also been witnessing that kind of behaviour. So finally, it wasn't a he said situation, it was a we have said. And that's not uncommon for people to wait quite a period of time before they make complaint. So complaint is raised. This led to the claimant being suspended, and the allegation was breach of the bullying and harassment policy. And he was informed that this concerned discriminatory behaviour that had caused hurt and offence to a colleague. He was never given the colleague's name. Lots of interviews were conducted, more noises were identified. And this one stood out for me. The claimant would apparently quite regularly make an orgasmic noise at work. So reminded me of Harry Met Sally. But anyway, there's now a range of noises that this claimant likes to make. And when this was put to the claimant as part of the investigation, he accepted that he did make some of these noises, nothing that could be race related or racist, but he in particular said, yes, one of them could be described as orgasmic. There you go. He also said that thinking back on it, it probably wasn't appropriate for the workplace. So the company decided to go through with disciplinary action, and he was eventually dismissed for gross misconduct. He appealed. The appeal wasn't upheld. And in any event, he got very angry halfway through the appeal meeting, started to bang his fist on the table, and then left. So where did it all go wrong? Well, there's lots of learning points here that the tribunal said. First of all, they said the exact reason for dismissal wasn't clear. The dismissal letter was far too general. They should have identified what noises it was the claimant had made, and what noises they found he hadn't made. Nevertheless, the tribunal outlined that the respondent clearly had stated the dismissal was after inappropriate noises or embarrassing juvenile noises had been made, and they were offensive to an employee. So it was fair to have led to a disciplinary process. What they didn't find was fair was to have dismissed him for it. Some other sanction, like a final warning, was more appropriate. But the tribunal agreed a reasonable investigation had taken place. They agreed the noises were inappropriate. The individual had, of course, admitted to those in any event. Um, but where they also fell short was that they claimed to have a zero tolerance policy against workplace discrimination, harassment, and bullying, as do most employers. Most policies say zero tolerance, which means don't do it at all. But then a tribunal will look at the reality of a workplace and say, well, do you always uphold zero tolerance, or do some things get through? And the claimant here was not aware that there was a zero tolerance policy, was not aware his behaviour could amount to gross misconduct, and was not aware that it could lead to his dismissal. And this is particularly true as it had been going on for so long and had been overheard by other people. So all the evidence pointed to the fact that the claimant hadn't been provided proper training, hadn't been provided the policy, didn't understand what this meant in practice. And there's the matter of warnings too. You know, if something's been ongoing and known and not dealt with, then it's very difficult to at some point jump straight to gross misconduct. So given the claimant's lack of knowledge of the policy and training, no previous warnings, the tribunal believed it wasn't reasonable to have dismissed him, and therefore he was found to have been unfairly dismissed. But they weren't done there, because they did find he was guilty and culpable and blameworthy of inappropriate conduct, because some of those noises were admitted, and they therefore halved his compensation. They reduced it by 50%, which meant he received, I think it was 10,600-ish, instead of, double that sum. I had a case once years ago where we reduced someone's compensation by 100%. So we felt procedurally they were unfairly dismissed, but substantively dismissal was the right outcome, and therefore it was right to remove all their compensation. So this person, I remember, was particularly happy for about 5 minutes when they told they'd won, and then they were quite upset when they told they'd won nothing, because it was all going to be removed. And there you go, lots of learning points here. I mean, as I said, I train on this all the time, and I'm going to add to my training not to make offensive noises. I told you last year about a case where a woman was slapped on the backside in a meeting with a ruler. I've since added that to my training. Don't slap people on the backside with rulers either. Sometimes you have to go back to basics. But there you go, the Michael Jackson orgasm case. Then we had this case. This was an office manager who called her manager and another director D heads. Obviously, there's a whole word that goes after the D initial, but I'm sure you can figure that out, during a meeting. And she too was found to have been unfairly dismissed. The judge said that this was a one-off comment in a heated moment meeting. And while it wasn't acceptable, it didn't amount to gross misconduct or something so serious as to justify immediate dismissal. The full comment that she said in the meeting was, if it was anyone else in my position, they would have walked out years ago due to the goings on in this office. But it's only because of you two D heads that I stayed. So she said it in a friendly way, I think she was trying to argue. Anyway, she got £30,000 and lost nearly half of that in legal fees. But anyway, there's always more to the headline. This was a very small employer, 6 employees, scaffolding and brickwork company. And the 2 people that she said this to were actually her brother and her sister-in-law. And that's all part of the factual matrix that goes into decision making for these cases. Apparently her brother responded by saying, don't call me and my wife an effing D-head. And she said, I've only said it in a jokey fashion. She tried to kind of, play down the offensiveness of that it might be offensive to other people. To which her brother said, well, that's it. You're sacked. Pack your kit and F off. She said, OK, I'll go. And then they tried to unpack that later when she brought her claim and said, no, we didn't mean to dismiss her. Pack up your stuff and F off wasn't a dismissal, which of course all failed with the tribunal. It's pretty clear what you mean when you say that. So there you go. They also, interestingly, tried to produce file notes of that meeting that the claimant said were never made at the time. And when I take notes in meetings, I always make a note of who is making a note, because I've seen this many a time when somebody tries to later produce a very thorough or different note of a meeting, and when in fact there was only one person writing anything down at the time. So if you're ever in that situation and you're in a meeting where there is one note taker and no one else is writing anything down, I would be clear about that. And the tribunal's pretty upset that they tried to produce this document at some later date and backtrack a disciplinary process. But there you go. So in some circumstances, even being that rude might not be worthy of a gross misconduct dismissal. Every case turns on its different facts and circumstances. The other thing to remember, if you do lie about something and you're found out about it, I'm definitely not promoting ever lying. Please don't do that. But if someone does, and then they're proven to have lied, then the tribunal is probably going to say, we now don't believe your evidence. We now find evidence of others likely to be more persuasive because your credibility was lost. You lie about one thing, you've probably lied about everything. And there were also costs made against this respondent for the way that they'd dealt with this case as well. So that one caught my eye. And then this one was interesting. The actual headline for this was "Dream On, IT worker fails to predict their own dismissal." And this was a case where an IT analyst was fired for harassment after telling a female colleague that he often dreamed about her. And in fact, a year before he'd even met her, she had been present in his dreams. And the tribunal had to decide whether this employee's belief that they had prophetic dreams should qualify as a protected philosophical belief under the equality legislation that we have. And they decided it did not, because actually this was just a belief in this person's own ability. This was a long-serving employee, senior computer analyst in this Workplace Computer Centre UK Limited, and he thought he could foresee the future in his dreams. He met this new colleague, Vanessa. He said, "I've been dreaming about you for over a year," and then started a whole load of unsolicited messages and poems, all very romantic, very obsessive though in undertone. Told her that she'd been haunting his dreams, in fact, and that he wanted to tell her stuff, but he was afraid how she might react. And he didn't want her to think he was pestering her, and he didn't want her to report him, but he felt he needed to keep telling her how he felt. Anyway, so it went on. She feels uncomfortable, maybe unsurprisingly, reports his behaviour. Investigation follows, and the internal investigation finds that the messages were unwanted, created a hostile environment for her, and amounted to sexual harassment. He was dismissed for gross misconduct. This time, the tribunal held that his dismissal was fair. They said the employer had a genuine belief in the misconduct, followed a good process, and the dismissal fell within the range of reasonable responses. However, they rejected his argument that his belief in being a prophetic dreamer was something that should be protected as a philosophical belief, because they said this was just a belief in your own abilities. So this case really highlights and reminds us that harassment is judged very much on the effect of the recipient, not the intention of the sender, and not everything is protected as a belief. But good process, good investigation, good, reasonable outcomes are what employers need to undertake when they have these kind of issues. And then the last one I want to tell you about caught my eye. This was when a very high-earning executive with ADHD was sacked after she spent the night sleeping in a sauna when she'd lost her room keys because she was too drunk at a team building event. I mean, you couldn't write this stuff. She was vice president of engineering at this employer, Gitpod, earning £220,000 a year, plus a very significant bonus. She went on this team building trip to Austria. After drinking too much one evening, everyone was drinking too much. She lost her hotel room keys, couldn't get away into her room, and so ended up sleeping in the sauna. Hopefully it wasn't on. So although unusual, this could have been seen as an embarrassing mishap. 2 months later, she was dismissed. And the official reason given was that her actions had caused colleagues to lose confidence in her leadership. Never a good idea to wait 2 months to rely on something. Anyway, the tribunal heard lots of evidence about this, that she had ADHD and a dyslexia diagnosis. She said she felt often overwhelmed. She sought support from her employer. That was never given to her. She sought an occupational health referral. That was never actioned. And she said her behaviour at the retreat, drinking too much, losing the key, making an unwise decision to sleep in a sauna, was all linked to her ADHD-related forgetfulness and the executive function challenges she had, and that was found to be correct. She brought 3 claims: failure to make reasonable adjustments by reason of her ADHD, discrimination arising from her disability, that being ADHD, and she also said sex discrimination. Men were as drunk as her and weren't treated in the same way, but she failed on that one. So we've got to be really mindful when people have a diagnosis such as this, especially if they highlight difficulties that they're experiencing. If people ask for adjustments, we should look at them. If they ask for a referral because they're struggling, then we should do that. And the tribunal, as I said, found that her forgetfulness and her poor decision making was related to her ADHD, and therefore that was discriminatory. So lessons to learn. Reasonable adjustments are a legal duty. Once an employer is aware of a disability, they must act. Failing to act is unlawful. There's great impact from neurodivergence that should be recognised: forgetfulness, overwhelm, poor decision making on occasions, carelessness can be disability related effects. Senior leaders need support too. The same legal protection applies to everyone, regardless of pay or position. People need to be trained on how to deal with these kind of things. Line managers are often that first line of support, and if they're not aware, their requests can be ignored or mishandled. We need to document everything, keeping records of requests, adjustments, steps taken, reasons steps aren't taken, notes of meetings. They're all really important. And if there is ever a tribunal, they are absolutely essential defence material. Using occupational health or a needs assessment is a really good idea. Don't make assumptions. You might know one person with ADHD that doesn't have that difficulty. That doesn't mean everyone is the same. So, make no assumptions. Deal with each case on its own circumstances and facts. And think about culture, off-sites, alcohol. I've sat on many a case where alcohol was the difficulty or the poor issue in the whole circumstances. So, if we've got events that include alcohol, think about how they are managed. Prevention saves you money. I've always said that. So there you go. In answer to my question, is a sauna a good place to sleep on a team building event? Turned out it might not be a poor place to sleep, or it might not be a career ending place to sleep. Anyway, let's move on to some legislation. So, as I said earlier, the passing into law of the Employment Rights Act of 2025 at the end of last year, it was the 18th of December, means that this year is a big year for employment law, and so is 2027. Lots of changes on their way, some this year, some next year. And there's a number of consultations taking place as well. I think there's about 26 different ones anticipated. Some are on 0 hours contracts, the status of workers, flexible working, collective redundancy, to name but a few. So lots on its way and lots still being consulted about. And then there's the normal April changes to be aware of, which I'll tell you about too. There's also a new equality, race and disability bill going through Parliament as well, and I'll touch on that for you too. So lots of legislation. Before we do 2026, I promised you in the agenda a very brief reminder of 2025. So let's start in January. This is where we had on the 20th of January, in fact, that an unreasonable failure to follow the fire and rehire code could increase any protective award made by up to 25%. I know I talked about this last year, but for those not on that session or unfamiliar, let me explain the fire and rehire concept very quickly. This came about, this code came about from the P&O ferry sacking of 800 workers, which you might remember a few years ago. They were given no notice and then re-offered their jobs a second later on far worse terms and conditions. I don't know if you remember that. But this brought about eventually this fire and rehire code, which was all about how to treat people reasonably in those circumstances. Because there's many reasons why an employer might wish to change terms and conditions of an employment contract. But where that change is unfavourable, nobody ever complains where it's favourable, where it's unfavourable to the employee, particularly if it relates to pay or benefits, then the employee in question might not give their consent to those proposals. And if the issue cannot be solved by consultation and/or negotiation, an employer can, in some circumstances, terminate your existing contract with notice and then immediately offer you a new contract on those new terms. And this practice is what's commonly known as the fire and rehire, or terminate and re-employ. Notably, the code states that fire and rehire should not be an automatic step. It should only be used as a last resort, and that the purpose of the code is to ensure that employers take all reasonable steps to explore alternatives to dismissing and re-engaging via meaningful consultation, which has the view to reaching agreed outcomes. So I think it's all in there from that very brief summary. All reasonable steps to, ensure that the consultation and agreement is reached if at all possible. It has to be a last resort. So what happened in January was the code said any unreasonable failure to follow the code could result in that 25% increase to the protective award. Then we saw in April all the usual annual increases, national minimum wage, family friendly rates, all those kind of things. I won't tell you what happened because I'm going to tell you what this year's looks like in a minute. We had on the 6th of April paid neonatal care leave. This was a new right, came into effect in England, Scotland and Wales. It was estimated, I think, that about 60,000 new parents would benefit. There was guidance given for employers and employees covering topics such as, how to make a leave request, how to handle one, what payroll adjustments were needed, how much statutory neonatal pay is, understanding the rights and protections available for employees who took or take neonatal care time off. And I think I've summarised it. I definitely summarised it for you last year. But essentially, it's a day one right. So you don't need a minimum amount of service to have neonatal care leave and pay. It will be taken after maternity or paternity leave. A parent is entitled to 1 week's leave for every week their child spends in neonatal care, capped at a maximum of 12 weeks leave. The parent can take that leave when their child is still receiving the neonatal care or after the neonatal care. And the Act also provides employees with protection from being dismissed or some other detriment due to having taken neonatal leave. And if they've got at least 26 weeks service, they're entitled to neonatal leave pay at the statutory prescribed rate, entitled to come back to their job and all the normal protections. So I'm sure you're aware of this because it was last April, but that was the introduction of neonatal care. Then on the 1st of September last year, we saw the failure to prevent fraud offence introduced via the Economic Crime and Corporate Transparency Act. Enforcement agencies now have far greater powers to hold companies accountable for any fraud committed by their employees or representatives. And if the company gains any benefit from that fraudulent conduct, whether directly or indirectly, then that's when they become liable under that new offence. And a conviction could result in unlimited fines, regardless of whether the individual themselves is prosecuted or not. This only applies to large organisations To be a large organisation, you have to meet 2 of 3 criteria. Either you have more than a £36 million turnover, you have more than 18 million in total assets, or you employ 250 or more employees. So this is only something for those larger employers. And I've put up on this slide the name of that legislation and the date it came into effect. So it, as I said, it captures fraudulent conduct carried out by associated persons, and that includes employees, agents, subsidiaries, those that act on behalf of the organisation. And the fraud has to be committed with intention of benefiting the organisation or their clients. If you're one of those large employers or you represent large employers, then that's probably of interest to you too. Then at the end of last year, 1st of December, the HR1 form was updated. This is the official form that employers have to use in large scale redundancies. That's 20 or more people affected. And this is the form that is used to notify the Secretary of State via the Insolvency Agency. It's about collective redundancies, and it's a requirement under the Trade Union and Labour Relations Consolidation Act. And as I said, a collective redundancy is a large-scale redundancy where an employer proposes to dismiss 20 or more employees at a single establishment within a 90-day period for reasons not related to the individuals concerned. So it can also apply in those fire and rehire circumstances. So it applies to collective redundancies, i.e. people leaving, but it also applies to big collective change. So where people aren't leaving, but they might be worse off, and you might end up, if there's no alternative, in that fire rehire situation. So there we go. We saw the changes to that form. And you have to comply with it. It's a criminal offence if you don't. Failing to complete that form or undertake the collective consultation is, as I said, a criminal offence that can result in companies and directors or senior officers being prosecuted. It comes with unlimited fines as well. And it also comes with the problem that any employee dismissed might be dismissed unfairly because of the failure to do the collective consultation process. So 20 or more people affected in some way, don't forget that there's this additional step, and it's quite prescriptive what you have to do to fairly consult in a collective consultation scenario. Also on the 1st of December, we saw the ACAS early conciliation window double from 6 weeks to 12 weeks. What does this mean? I hear you say, or rather, I've imagined you might say, well, this is the mandatory free confidential service that ACAS offer when somebody brings a tribunal case. They don't offer it from the goodness of their heart. They offer it because they're required to. And a conciliator, an ACAS conciliator, will contact an employer when a tribunal claim goes in to try and resolve the issue. And what's happened is, instead of having 6 weeks to try and resolve the issue, they now have 12 weeks. If someone wants to go to a tribunal, they've got to go through this ACAS process first, fill out the form, say if they want early conciliation or not. You can say not. You don't have to go through that process. The employee can say they don't want to. The employer can say they don't want to. But you have to go through the process in order to get something that's called an early conciliation number. You can't raise a claim to the tribunal without inserting the EC number. So that's why it's mandatory. And it's worthwhile, ACAS try and resolve issues. They have separate discussions with both sides, see if they can explore some solutions. The goal is to avoid the tribunal hearing, and there's 12 weeks for that to happen. It also extends timeframes. I'm going to talk about timeframes a little bit later as well, because it kind of stops the clock. If settlement is reached, then it's binding. ACAS produced something called a COT3 form, COT3. Both parties sign it. Both parties have to stick to it. It's legally binding. If no agreement is reached, then the early conciliation certificate is issued with that number. The number goes into the employment tribunal claim. ACAS have recently reported a 26% increase in early conciliation, and that really goes hand in hand with the increase in cases. And the wait to get a conciliatory is about 5 weeks, so doubling it to 12 weeks is pretty much essential, to be perfectly honest. Okay, and another change that took place as soon as the Employment Rights Act legislation was passed on the 18th of December 25 was that the minimal service level rules for strikes in some public services was removed. So these were rules, you might remember this, there were so many strikes at the time when this legislation came in. This legislation was about keeping important public services running during a strike, like healthcare, all the transport strikes, education. But in practice, this was a technicality, as even though the legislation arrived, no employer ever invoked the powers that they had, and now it's gone because it was repealed on the 18th of December. So I see little point in telling you any more about it because it was here, it wasn't used, and then it went. Then also we've had the something called the Data Use and Access Act. It's shortened to the DUAA. This act arrived and brings significant changes to the data protection landscape, if that's an area you're involved with. It includes targeted reforms to the GDPR legislation, to the Data Protection Act, and it received royal assent in June 2025, but its provisions are coming into force in stages. They started in June last year and they will continue through to June this year. So if you're involved and you're on the receiving end of a data subject access request or a DSAR or a SAR, you'll know that these are pretty costly and time consuming, often involving complex and large scale amounts of data that has to be carefully examined and considered. It's a go-to response now when an employee is disgruntled and upset and or wants to bring an employment tribunal case or raise a grievance or is at risk of dismissal. You often find that a data subject access request is made, and it's often used for people to slow down processes. It's not an area that I work in myself, but I've tried to summarise on the next slide what the key parts of this are. Please go away and have a look at it if it's something that you are involved with. I mean, there's some good things like only reasonable and proportionate searches are required. It's a central change in that the requirement is that the business need only conduct reasonable and proportionate searches when responding to a data subject access request. Previously, the law was less clear and some organisations were compelled to undertake exhaustive and resource intensive searches. I mean, I would get legal advice if you have one of these, and it's it does involve a lot of data. It requires the second point there, requirement to introduce a complaints procedure. So you can no longer tell a dissatisfied data subject to go directly to the ICO with their complaint because you now have to have an internal complaint handling process. So, at some sort of complaints procedure. The legislation also introduces a new court procedure for DSAR disputes, which we didn't have before. So if a dispute arises, the court can require you to disclose to it relevant data for inspection. However, there's no disclosure to the data subject until the court has ruled in their favour. But anyway, it probably means take even more care when you consider a data subject access request, because there can now be a litigation threat. Fourth point there, it clarifies that information protected by legal professional privilege does not need to be disclosed. We knew that anyway, but it's been put into that legislation. So it's completely clear now. And then finally, it confirms into law that ICO guidance on timeframes has to apply. So have a look at it if it involves you or any of your clients or the people that you work with, because it's, particularly the complaints procedure is probably an important additional step. Okay, so let's move fully into 2026 now. So again, I'm going to start in January and go forwards. It seems to make sense. From the 21st of January, self-employed workers in England and Wales gained access to enhanced DBS checks for the first time. It was basic DBS checks before only, and that wasn't good enough for working with children or vulnerable adults because that's when the enhanced was required. So employers can now ask self-employed contractors like, private tutors, therapists, carers, freelance care workers to obtain an enhanced DBS check as part of the recruitment process. The amendment to the Rehabilitation of Offenders Act of 1974 means that employers can then suitably assess candidates before they are hired for regulated activities. Sorry about the rather dramatic photo. It's impossible to get a royalty-free photo that relates to the Rehabilitation of Offenders Act, but there you go. So this is very specific to those kind of areas where self-employed workers are hired in those areas where enhanced DBS checks are needed. But if that is you or you're involved in that, then take a look. Also on the 21st of January this year, the government published 5 updated fact sheets covering different aspects of this new Employment Rights Act of 2025. And I've listed them there on the slide. So they relate to preventing workplace sexual harassment, public sector outsourcing, social care negotiating bodies and fair pay agreements, trade unions and unfair dismissal. So some important new fact sheet areas that have been updated there. The fact sheets are supposed to provide, clear, accessible, an overview of the reforms introduced by the new legislation. If you're involved in those areas, definitely go and have a read. Each one sets out what's changing, how the new legislation differs from the old legal framework that we had. It says when the changes are expected to come into play and whether further consultation is planned. In some areas, notably workplace sexual harassment and unfair dismissal, the fact sheets also include some headline statistics and responses to commonly asked questions as well. So a lot of what I'll talk about today is covered off in those fact sheets too. But if you want somewhere to go and have a look, that's a good place to start. So a poll for you now. If 100 workers are eligible to vote for a strike and 49 of the 100 vote and all 49 vote in favour, can the strike go ahead? So what do you think? Some of you may be involved in unionised environments and some of you may not. If not, give it a guess. So 100 workers are eligible to vote for a strike, 49 vote, all 49 vote in favour. Can the strike go ahead? So just answer yes or no for me, please. I think once we've got enough or most people, then we'll put up the answer for you. And I hope you can see that answer. It's a pretty good split. So 49% of you said yes, if that were to take place, the strike can go ahead. And 51% slightly over said no, it wouldn't. And the majority there, it's a tiny majority, but it's still a majority, are right. No, it wouldn't, because whatever numbers there are, you still have to have a 50% turnout requirement. At least 50% of all the union members, the employees that are union members entitled to vote in that ballot must vote. And then at least 50% of those who vote must vote in favour. So if there's 100 people in the ballot, as in our example, at least 50 must vote for this to get off the ground at all. And here only 49 did. And then once we know how many have voted, the majority must vote in favour in order for it to go ahead. Thank you very much. That was very split down the middle. I've got another one, I think, for you now. Yes. So if 100 workers in an important public service are eligible to vote for a strike, and this time 50 vote, so we've got the majority now, we've got 50% now. Of those 50 who voted, 39 voted in favour, so it's a majority of the 50. Can the strike go ahead? So similar, 100 workers again, it's a public service. If 50 decide to vote and 39 vote in favour. Can the strike go ahead? Another just yes or no. I hope this highlights how complicated it is when you get into trade union related legislation and unionised workplaces. So yes or no. Let's see what people think this time. Oh, this time we've got a bigger majority. So 64% have said yes and 36% have said no. And again, the majority have it. The answer is yes. This time, the 50% turnout is met and a majority have voted in favour. Now, some of you might be saying no, because it used to be in important public services, there was a third obligation to get a strike over the line. And that was that those who voted in favour as a number had to be equivalent to 40% of the total. So pre the 18th of February, when the legislation changed, the answer to this question would have been no. You would have had to have had over 40%, so that's 40 or more, saying yes. And in this example, I told you that only 39 said yes. However, the legislation has changed. That 40% is no longer a necessary step. So as of the 18th of February, this strike could go ahead. So soon, unions will only need a simple majority of the members who respond to a strike ballot to vote in favour, and then the vote will be able to go ahead. Because, I'll tell you about this a bit later, the 50% turnout is disappearing as well. So not only is the 40% gone, but soon the 50% will go as well. And that essentially means if we have 100 people eligible to vote and only 10 can be bothered to vote, only 10 people vote, as long as 6 vote in favour, the strike can go ahead. So the number of people that have to say yes to a vote will decrease massively from what is necessary at the moment. But I'll remind you of that when we get to the right date. Okay, thank you for doing that. Right, also on the 18th of February, just 2 days ago, other changes took place that relate to trade unions. And it just makes it all a little bit more or a little bit less burdensome for the trade union to organise industrial action. And I'm going to put the main changes onto the next slide. But essentially, unions will need a simple majority vote for industrial action, for a strike or action short of strike. It will give greater protection for people dismissed whilst taking part in industrial action. It becomes automatically unfair. The time needed to give notice of a strike will reduce. There's changes to picketing rules. Industrial action mandates will last longer, and industrial action and ballot notices will be simplified. So, as I said, I've put it up on the next slide. This is obviously very particular to workplaces where there is a trade union recognised. So I won't give you any more detail on it. As I said, it essentially makes bringing an industrial action into a workplace easier, less burdensome for an employer, for a trade union, sorry. So I think it summarises it fairly straightforward on this slide. But if there are any questions, let me know, or go and have a look at this legislation. I do lots of training and lots of work in unionised workplaces. I train managers on what they need to know when they're negotiating with employees that are trade union members or trade union representatives. There's lots of legislation, lots of bureaucracy, lots of rights and protection for people. There you go. So that's the trade union piece. Lastly, there's been updates to the codes of practice on picketing and industrial action ballots and notice to employers, as you would expect, because the legislation's changed. So those codes of practice have altered as well. Okay, then we are at the 6th of April. So this is 6th of April 2026, yet to come, and there's quite a lot of change envisaged. So we have enhanced whistleblowing protection on sexual harassment This means sexual harassment will be a qualifying disclosure under the whistleblowing legislation. I'm going to expand on that in a little while. And so that's the first thing that will change. The second thing is there are changes to statutory sick pay. SSP will be payable from the first day of sickness absence instead of the fourth day. So the concept of waiting days will go, and the lower earnings limit for eligibility will also be removed. Essentially, more people will be eligible for SSP, and employees earning below that lower earnings limit will also be eligible, and it's payable at the lower of the weekly rate or 80% of their average weekly earnings. And there's changes to SSP, and I'll give you those shortly. We've also got, not on the 6th of April, actually on the 7th of April, the introduction of the Fair Work Agency. This will be established to bring together existing enforcement bodies into one agency, and they will be granted quite considerable powers, actually. The Fair Work Agency will be able to investigate and take action against businesses that don't comply with some aspects of employment law. So they will probably take on the enforcement of rights such as holiday pay and SSP that we've just been talking about. They can also bring a tribunal claim for a worker, even if that person doesn't want to do it themselves. So they will have quite a lot of rights, the agency. Then paternity leave will become a day one right. What this means is someone will be able to give notice of paternity leave from the first day of employment. At the moment, they have to work for their employer for 26 weeks before they have the right to have paternity leave. That becomes a day one right in April. And the Act also removes the requirement for paternity leave to be taken before shared parental leave, which should give employees more flexibility on what type of leave to take. And unpaid parental leave will become a day one right too. Again, at the moment, for unpaid parental leave, you have to have 26 weeks service. You won't when the legislation changes. So it allows someone to give notice of paternity leave and unpaid parental leave from day one of their employment. And then finally, two other things. Employers will need to create action plans around the menopause. And it will be voluntary to start with. Not all employers, some employers. Again, I'll tell you more about that shortly. It will be voluntary to start with, and then it will be mandatory in 2027. So menopause action plans on their way for some. And then, as I've already said, there's more changes to trade union legislation, simpler recognition process, and changes with collective redundancy protection as well. So I'll come on to some of those. The first one I mentioned was the enhanced whistleblowing protection on sexual harassment. So from the 6th of April, workers and employees who report sexual harassment at work can benefit from protection under whistleblowing legislation. I don't know where I got this couple from. I do love them so much. It's so age and disability friendly, and they look like older workers. And she doesn't have enough fingers, and he has one too many, which I only noticed about a year ago. But anyway, enhanced whistleblowing protection for sexual harassment. Key changes are that the law will make it clear that workers who blow the whistle on sexual harassment at work can benefit from whistleblowing protections against detriment and dismissal for blowing that whistle. Previously, a worker would have to claim that their whistleblowing disclosure was about sexual harassment under one of the other categories of wrongdoing. So it was difficult. You'd have to say, well, it was a danger to health and safety, for example. This change makes it much clearer. So what you need to do if you're involved in policy, you need to have a look at your whistleblowing policy, review and update it, maybe brief managers on the updated protection. People don't spot whistleblowing unless it's very, very obvious. I see so often whistleblowing issues are just not recognised. For those of you who aren't familiar, I've got a very speedy summary of whistleblowing for you. Whistleblowing is the action someone takes to report wrongdoing at work that affects others. So it's a public interest disclosure legislation. So it's wrongdoings at work that affect others. And legally, that's known as making a disclosure in the public interest, and people call it whistleblowing. People, not self-employed people, not NEDs, not volunteers, but people who are employees or workers are protected if they make a qualifying disclosure. And protection starts from the very beginning of employment, and it still lasts even if someone's no longer employed by the employer they make the disclosure about. And there used to be 6 specific categories of wrongdoing. We now know that's being extended. And the 6 current ones are a criminal offence, a failure to comply with a legal obligation, a miscarriage of justice, health and safety risks, environmental damage, or the attempt to cover up any of the above. And if someone were to raise a concern, blow the whistle for any of those reasons, the protection they're given is against being unfairly dismissed and against any detriment, i.e. being worse off after you blew the whistle than you were before. So you've been, bullied, you've been overlooked for promotion, you've had your work changed, you've had, your negative responses from your employer to a reference, for example. So they're the kind of detriment people look at. So to be able to have the protection the whistleblowing legislation gives, you have to make a qualifying disclosure, you have to follow the correct disclosure procedure, and then there has to follow a dismissal or some other detriment because you made that disclosure. Okay. And unlike standard unfair dismissal claims, whistleblowers aren't subject to the statutory cap on compensation. So if you can show you were dismissed because of the issue you raised, then it's automatically unfair and there's the potential of unlimited compensation. Whereas with normal unfair dismissal claims, there is the cap, which you'll be familiar with. Okay. It's a very complex area. There's a whole concept called interim relief that I'm not going to go into, but if people raise complaints that are whistleblowing issues, again, if you're not familiar enough, get some advice because they are complex areas and they do give rise to big protection for people. And whilst talking about sexual harassment, on the 21st of August last year, Lidl GB entered a legally binding agreement with the EHRC, the Equality and Human Rights Commission, and their agreement was that Lidl committed to make lots of changes to provide a better workplace and more protection for workers from sexual harassment. So this is an unusual step. We saw McDonald's have to do it, and now we've seen Lidl do it. So the agreement states that there is a high risk of sexual harassment in that workplace, and therefore Lidl has to do lots of things. The first thing is they have to run a staff survey to assess the level of the problem. They have to develop a system to monitor and analyse formal and informal complaints. They have to identify and have a plan for the risks that have been identified. They have to monitor the effectiveness of how complaints are handled. They were required to review a sample of sexual harassment complaints to look for any trends. They have to meet with existing DE&I groups, diversity, equality and inclusion groups, to discuss those findings and those risks. And they have to review their internal harassment policies and training. So this came about from a particular tribunal complaint brought by a lady called Miss Hunter, where Lidl was found to have failed to take reasonable steps to prevent the sexual harassment of this staff member over a number of years. And the headline for that case, I love a headline. This headline said, "Laddish culture costs Lidl 50,000 after female employee won sexual harassment complaint." I always talk about the importance of staff training and good policies and people knowing about the policies. And this Hunter and Lidl case is a classic example of why employers must well publicise, update, enforce and educate on their policies. And I don't think you can underestimate the importance of good line management, dealing with issues, being open to hearing issues, making sure people feel safe to raise problems at work and so on, setting the right tone, being the right role model, all of those kind of things. This was an employee, Miss Hunter, and she was paid quite significant compensation because her manager and other staff thought the way she was treated was nothing more than workplace banter. Oh my goodness, if I had a drum to bang about workplace banter, it would be that. So she worked for Lidl. She was a teenager when she joined and was almost immediately subjected to unwanted advances and comments from fellow employee. She complained to her store manager. He said, I think you should take it as a compliment, which is amazing. And that he wasn't surprised by that kind of comments, and it's just a joke, and made jokes about it. So she found no support at all. She continued to be harassed. This included by deputy store manager. She had her backside touched, her thighs, her waist. He attempted to hug her on several occasions. He actually slapped her backside. He made a number of highly sexualized comments to her, asked her about her sex life, her underwear, her appearance. And in the end, she resigned and brought a claim. And I don't think you'll be surprised to hear that she won. So it was put down to be workplace banter. And one of the managers actually even said, come on, it just lightens the atmosphere. Other managers took part. There was even a ranking of female employees on their perceived attractiveness by a line manager. And none of them seemed to understand how upsetting and offensive all of that behaviour was to this individual. So there you go. I think we've got to make sure that people understand what the rules are, the policies are good, we've educated and trained, and that line managers step in and deal with issues. And in this case, it was found that Lidl had failed to train on its anti-harassment policy or explain the duty to managers. Staff training, I think they said, was poor to non-existent. There you go. She got £50,800 odd pounds. Which included £22,000 for injured feelings and interest on her award too. So prolonged sexual harassment over a lengthy period of time was the finding. Okay, before we go to SSP, it's 10 o'clock, good time for a break. Let's just take 10 minutes, time for you to have a quick comfort break. So back at 15:15, if that's okay. I'll give me time to have a look and see if there's any questions. So I'll see you shortly. Thank you very much. Welcome back, everybody. Hopefully you can hear me okay. I've seen that somebody very kindly has referred me to Unsplash for some royalty-free photos. I haven't come across Unsplash before, so I will definitely go and have a look. Thank you very much for that. There's also a point made about the Rehabilitation of Offenders Act, and yeah, it's very prescriptive. And I've just found during the break, NACRO, which is a government body, NACRO, they actually have a great poster about what the obligations are under the Rehabilitation of Offenders Act. So worth going there for a reminder if you want to look at how long it is before something is spent and no longer has to be raised with an employer. And then I've got a question to answer. So thank you for this question. It says, an employee goes on sick leave. Employee goes on the sick leave and receives SSP for the maximum period of 28 weeks. The employee stays off work and supplies sick notes. The employer is afraid to dismiss the employee for fear of being brought to an employment tribunal for unfair dismissal, for example. How can an employer safely, without being taken to tribunal, terminate the employment of an employee in those circumstances? Well, this is a very typical situation when there is long-term ill health. So exhausting the SSP entitlement means that they go on to unpaid leave unless there's contractual sick pay that goes over and above 28 weeks. But let's assume not, and they're now on unpaid. As an employer, you've got to issue the employee with, I think it's called an SSP1 form, because they can go on to claim other benefits potentially. The law then doesn't say, oh, good, they've exhausted SSP, you can now terminate them without risk. But the law does allow us to terminate people's employment by reason of capability. And capability is twofold. One, certain types of capability dismissal fall into the underperformance category, and other types of capability dismissal fall into the sickness absence category. And long-term sickness absence without the ability for someone to return to work within a reasonable time frame is a potentially fair reason to dismiss, but you've got to follow a fair process. And one of the things that I always have all my clients have in-house is a short and long-term absence management procedure. Set out how you will deal with either repeated short-term absence or a long-term ill health absence. Set out the steps. What meetings will you hold? When? What will be covered? What's the risk to employment? You know, obviously, if someone's off for 28 weeks, that's a very long time, and potentially they could have a disability under the disability protection under the Equality Act. And if someone has a disability, then we've also got that obligation to look at reasonable adjustments to allow that person to work. So there's another step that needs to be taken there. So the answer to the question is that it is lawful to dismiss people on long-term absence, but you have to follow a fair capability dismissal process. And if you have a policy that sets out what that process is, it makes life so much easier. Obviously, where you have to have up-to-date a medical assessment before you consider dismissing, and it's there that you would say, what's the prognosis? How much longer is this person likely to be off? Will they be returning within a reasonable timescale? And it's almost a balancing act that a tribunal will look at. You've allowed that person to remain an employee for 28 weeks, so you've covered their absence in some way or another. Has the balance now tipped that you can't continue to do that, or it's too expensive to do that, or whatever, you know, it might be. So you can dismiss people on long-term absence. You have to follow a fair capability dismissal process beforehand. Hopefully that's helpful. But yeah, there you go. It is possible. You just have to do it right. Okay, so we were talking about SSP. The Employment Rights Act, the new act, will require employers to pay statutory sick pay from the first full day of sickness absence, removing, as I said, the 3-day waiting period, and it removes the lower earnings limit. So eligible employees will get either SSP at the flat rate, or if they earn less, it would be 80% of their weekly earnings, so whichever is the lower. And those changes are expected to come in on the 6th of April. And obviously, it's going to increase the number of people eligible for SSP and bring forward the point at which payments must begin. So now is a good time to have a look, speak to payroll, calculate any extra cost that might arise from this, amend your policies, because most policies say SSP is payable after the waiting days. Obviously, that needs to go. You know, think about how you're going to manage absence going forward. Obviously, the rates change as well, which I'll come on to a bit later. But there you go, 2 changes on SSP. Let's see if I can make the slides go forward. Right. Then we have the family-friendly changes coming in on the in the April changes too. So this will make paternity leave and unpaid parental leave day 1 rights, removes the prohibition of taking paternity leave if shared parental leave has already been taken. And at the same time, the bereaved partners paternity leave regulations of 2026 will extend paternity leave entitlement for bereaved partners for up to 52 weeks, where the child's mother, primary adopter or primary adopter dies within a year of the child's birth or adoption or placement for adoption. And these extended rights will apply where the child's mother or primary adopter dies on or after the 6th of April 2026. Very similar rights are provided for parents in surrogacy cases as well. Previously, bereaved partners had to rely on compassionate leave to be granted any time off to grieve and care for their child should their partner die. So again, time to update your policies. Obviously, the bereaved partner paternity leave policy is likely to, well, hopefully as well, likely to be only relevant to a very small number of employees, but it exists, and if you have thorough policies, you'll need to make that change as well. And what I've done, I'm not going to read you this slide. It's really there for me to summarise so you can read it at your leisure. It just details what I've summarised to you and the transitional rules that come into effect as well. So I've put that over a few slides. This is more on that Paternity Leave Bereavement Act. And yeah, I've summarised it over those 3 slides. So if you've got policies that are relevant to this and you need to update them, please do. gov.uk has loads of great information if you're looking for ways to summarise it easily, or the ACAS website as well is very good. Okay, I also mentioned as part of the suite of April changes that we've got this menopause action plan coming in for some too. So from April 2026, employers with 250 or more employees will be encouraged to voluntarily publish an annual menopause action plan. And then from April 2027, it will become mandatory. And also menopause guidance will come into effect in April 2026 too. And I don't know if you remember, or you may not have been on the session, but a few years ago, there was a real push to have the menopause added as the 10th protected characteristic in the Equality Act. So we know what the others are, things like race, sex, disability, sexual orientation, the disability. There's 9 of them, and there was a push to have the menopause added as the 10th, and the government rejected that because there's so many successful cases for people who have been less favourably treated by reason of the menopause that have been brought under either age as the protected characteristic, disability as a protected characteristic, or sex as the protected characteristic. So it was turned down. No need for a separate menopause protected characteristic. But there you go. So these are action plans. And I'm sure if your employer or if you're involved in this in any way will know that there is a significant impact on many women's physical and mental well-being during the menopause. There's been many reports on this. Have a look at the Fawcett report in 2022 if you're interested. I know I've told you about various cases and in the tribunal over the years. And this is all about having a structured plan in place to provide appropriate levels of support, address challenges proactively, make those kind of adjustments to assist employees. All about employee retention and reducing absenteeism and positive work environment. And I've just put on this slide the kind of things that you might want to think about or look at. Awareness and education, regular training sessions is really important, I think. Providing accessible resources. You could even have guest speakers come in and discuss health-related issues. Talking about and looking to provide a supportive workplace environment, I think is a very important part of that plan. Think about flexible working arrangements, whether that's flexible working hours, maybe some remote work options if it's possible, a comfortable workplace, temperature-controlled workplaces, rest areas, and so on. I work with a client who has menopause champions that offer kind of individual support and coaching for people. Third one there is health and wellbeing support. Some people offer health screening, access to medical advice. If you have an EAP, an employee assistance program, reoffering the confidential counselling services that can provide. Some employers have support groups or other wellbeing initiatives, yoga, Pilates, mindfulness, stress management, all good things, not just to support people during the menopause. Policy and procedure. Having a clear menopause policy to go with your action plan is obviously going to be important, or you review existing policies to see whether they are menopause friendly, shall we say. Communication and engagement, talk about these things, have line managers talk in one-to-ones with people where necessary, have that kind of inclusive culture. So it's okay to talk about it and support people. And then finally, monitoring and evaluation, track your progress, regularly review the effectiveness of the menopause action plan. Maybe you do, confidential employee surveys, try and find areas for improvement and so on. So just a few thoughts there. If you are in this category, 250 plus employees, and want to or want to do something, you don't have to just be captured by the number of employees to want to do something along the menopause. And I don't know if you remember this head grabbing, attention grabbing headline a few years ago. It was menopausal railway staff offered jelly babies. I mean, it can't help but capture your attention. How very thoughtful of Avanti West Coast to provide their menopausal employees with a gift bag that contained, among other things, a jelly baby. What a nice thing to do. So unfortunately, it wasn't deemed to be a very nice thing to do and was found to be a bit condescending, patronising and demeaning. But anyway, what they did was they gave out packs to staff during the menopausal support drop-ins, I think they called it. And it had useful items in this gift bag, things like a fan, a jelly baby, and attached to it was, sweets in case you feel like biting someone's head off, a pack of tissues in case you're feeling emotional, a paper clip to help you keep it all together, a tea bag because tea makes everything better, a candle to remind you that there's light at the end of the tunnel, and a penny to bring you good luck. I think there was also a pencil to write down the things you might forget. Oh, and chocolate, because hey, chocolate, it's a great excuse to eat chocolate. Anyway, Avanti gave out these packs and they were absolutely slated for it. I think one of the unions said the menopause is debilitating for women. It's not a joke. Rather than handing out insulting gimmicks, you'd be better placed putting in workplace policies and procedures to value and support women. Anyway, there was an awful lot of backlash. It was interesting though, because it was their menopause diversity, equality and inclusion group that actually came up with the idea. So a woman there suggested that this would be a good thing to do. So it just goes to show what one person thinks is a good thing in some circumstances may not be in another. And sometimes we need to think broader, maybe. But it definitely caught my attention a while back. A jelly baby in case you feel like biting the head off someone. Anyway, perhaps we should all have jelly babies. Perhaps that should be compulsory for workplaces. Moving on, also 6th of April, we have the collective redundancy changes. This is an increase in the protective awards for failing to comply with collective redundancy consultation. So at the moment, if an employer fails to comply with their obligations, I explained this is about 20 or more redundancies at an establishment within 90 days. If an employer fails to comply with their collective consultation obligations, then up to 90 days actual pay is payable per employee for that failure. It's really expensive to forget to collectively consult. And that's why I'm always saying to people, if you're making a number of people redundant or you're in those fire rehire situations, have you triggered collective consultation? Because if you have, it's really expensive not to do it right. So the change is that it goes from 90 days pay per employee affected to 180 days pay. It's doubled. So it becomes even more expensive. And it's one of the most simple and straightforward provisions of the new Employment Rights Act. It couldn't be simpler what they're doing. It was 90 days. It will go up to 180. Tribunals can still apply a further 25% uplift if the company failed to comply with the code. I told you that the code came in last January, so there's a further 25% uplift for failing to comply with the code. So basically, the impact of this change is employers in those large-scale consultation places face higher financial risk if they don't do it right. So good and early consultation, even more critical. Okay, leaving April now. As I mentioned, we've got more changes to trade union legislation throughout. And um, one of the ones that's coming in, sorry, is the introduction of e-balloting and workplace balloting for statutory ballots, and that comes in August 2026. And at that point, the 50% turnout obligation will be removed. So you won't have to have half the number of people eligible to vote have to vote before industrial action can take place. If 3 people vote and 2 vote in favour out of 1,000 people, that's still enough to allow a strike to go ahead when this change comes in. So that's happening in August, e-balloting and the 50% turnout obligation being removed. Then in October, according to the UK government's Employment Rights Act roadmap, and there's been some changes to this in the last few weeks, so I've updated the slides accordingly. But there has been some shifting in when things are coming in. So have a look at the Government Employment Rights Act roadmap periodically if you're involved in bringing this legislation into your workplace, because sometimes dates shift, and something that was coming in 2026 might now be coming in 2027. Anyway, this is as it stands currently, and these are 4 of the most important changes predicted for October this year, some of which will require secondary legislation to bring them into force. So we've got increasing rights for trade unions, and this is all about when we get to October. Access, that includes physical and digital access for unions into workplaces. It also introduces an obligation for employers to tell their employees that they have the right to join a trade union. They don't currently have to tell them they have that right now, but it introduces the right to tell people that they can join a trade union. It brings in new rights and protections for trade union equality reps, who will for the first time have a recognised right to time off, access to facilities and so on. At the moment, there's different kinds of trade union reps. There's your sort of standard rep. There are training reps. There are pension reps, health and safety reps, and there's also equality reps as well. So extension there. Then secondly, employers will be required to take all reasonable steps to prevent sexual harassment of their employees. At the moment, the obligation is to take reasonable steps. So the difference is the word all. So a higher burden potentially. Secondly, there will be an obligation brought in for employers to prevent third-party harassment. Again, the obligation is to take all reasonable steps to prevent third-party harassment. That's harassment from members of the public, clients, customers, suppliers. Currently, there's no standalone employer liability for workplace harassment by a third party at all. It just doesn't exist. So that's an introduction. Unhelpfully, though, regulations to assist businesses on what this entails is not expected until 2027, even though the change is October 2026. But there you go. I think we need to look at carrying out assessments, publishing and updating policies, training and education, how you're going to report and handle complaints. If you look back at the menopause action plan suggestions, something similar is probably a good idea. When it comes to harassment, telling people what the policy is, upholding the policy, and training and educating people are key steps that need to be taken. So my third bullet point there is that there are changes to the employment tribunal limits coming in October. This will affect most types of claims to the employment tribunal. I'm going to expand on this one in a second. The government timetable actually says that this change will not come into effect before October 2026. So I guess that might mean it could be after October 2026. So not before. And we also see continued consultations associated with changes from the Employment Rights Bill. And then lastly, tightening tipping law. So it will become mandatory for employers when developing their tip policies to consult with workers at that place of business, and for employers to be required to review their tip policies at least once every 3 years. So there's 4 of probably the most important changes predicted for October. We'll dig into these a little bit deeper. So here's another poll for you. If I were dismissed on Friday, the 17th of October 2025, on or before what date must my claim reach the Employment Tribunal? So if you were dismissed on the 17th of October, how long have you got essentially for your claim to reach the Employment Tribunal? So I've given you 5 options. Have you got 1 month? Have you got 3 months? Would it have to be there by Friday, the 16th of January, the 17th being a Saturday? Do you get 6 months or do you get a year? So which one of those do you think it currently is? Let's see how you think which one you're going to go with of those 5 options. Okay, I can see this. I don't know whether you can. So nobody thought 1 month. 39% thought 3 months. 38% thought 16th of Jan. 18% thought you had 6 months and 5% thought you had a year. So we've got no one for the first one, but we've got a number over the rest. Obviously, 3 months and the 16th of January are by far where the most of you voted. And C is the right answer. The reason it's not 3 months is because the legislation says it must be received within. So it is 3 months minus a day. If I'd have put 1 month or 3 months minus a day, then that would have been correct. B or C would have been correct, but 3 months would be 1 day too late. So C is the right answer, but it's got nothing to do with the weekend point because you can put your claim in on a weekend. If you experience discrimination on a specific date, because you don't have to leave your employment to bring a discrimination claim, then the 3-month period usually starts from the date you experience that act of discrimination. Some exceptions exist when there's ongoing discrimination, and then you add the time period together. So this is the last of a series of acts, for example, if there's ongoing discrimination over a period of time. And there are some circumstances where late claims can be accepted, but they're exceptional circumstances. So remember also, before you submit your claim, you're required to notify ACAS. You have to go through that early conciliation process. And that early conciliation pauses the limitation period. It stops the clock. And we know from the 1st of December 25, early conciliation can last up to 12 weeks. It got doubled. And you will always have at least 1 month after receiving your early conciliation certificate and number to then get your claim into the tribunal. However, the reason I put this up here is from October this year, October 2026, most time limits are going to double and they will extend to be 6 months minus a day, not 3 months. So it's a big change. It's going to give people a lot longer to decide whether or not they want to bring an employment tribunal claim. Okay, well done though. Most of you were in the right arena with that one. So I've put on this slide what it is. Time limit for most claims will be extended from 3 months to 6 months. And this includes your unfair dismissal claims, your discrimination claims, your deduction from wages claims. There are a few exceptions. Claims for unpaid redundancy pay already has a 6-month limit, but generally employees must act as quickly as possible to meet their deadline. If you miss the deadline, you risk losing your chance to bring the matter to a tribunal. You would have to then fall into the I have got an exceptional circumstance as to why I didn't meet the deadline. So basically, people will have more time to gather evidence, seek advice, make a decision whether they want to go to a tribunal claim or not. Okay, Moving on, we also have some of these things to think about, aside from the changes brought about by the Employment Rights Act. There's further developments to watch out for. There's a consultation on employee status. The government has committed to reviewing the current 3-tier framework we have in the UK. I know I've talked about this in the past, but we have employees, easy to spot, have a contract of employment. We then have workers. These are people providing individual service to an employer, but they're not an employee. And then we have the genuinely self-employed. And there's been a suggestion by the government of moving towards a 2-tier framework. So essentially removing the distinction between an employee and a worker. So we'll either have option A or option B, self-employed. And then we've got the Equality, Race and Disability Bill. It's anticipated that this draft bill will be introduced later this year, covering matters such as reporting, equal pay and dual discrimination. I'll tell you a little bit more about that on a later slide. Tighter restrictions on non-compete clauses in employment contracts. This has been mooted and hovering around for some time now. The government published a working paper on reform in this area back in November 2025. And there's been suggestions that clauses could be subjected to a maximum restricted period of 3 months and other options. And I'll go through what those options are in a second. And then there are further government consultations expected on areas such as AI in the workplace and reforms to TUPE. TUPE is the Transfer of Undertakings Protection of Employment Regulations. And if whistleblowing can be complicated, TUPE can be far more complicated. For the AI, the government has said that it's seeking to put in place rights and protections which reflect, technological change and safeguard against discrimination. So we have to watch out for those too. Obviously, next year, if something comes of those, I'll tell you more. So on the working paper, inviting options on reforming non-compete clauses, these are the restricted covenants about what you can do when your employment ends. The response to the working paper came in on the 18th of February, and it said that responses will inform the government's engagement with relevant stakeholders before decisions are made. But these were some of the options. So option 1 was to introduce a statutory limit on the total length of a non-compete clause. So it was said that a statutory limit would protect workers by stopping the amount of time that they're not able to work in their area of expertise. But the government didn't indicate what that period of time should be. So first option was we'll just have a legislative limit on a non-compete clause. The second option was to have a statutory limit on the length of a non-compete clause according to company size. So different size employer, different length of non-compete clause. So a large employer, might have 6 months, a smaller company might have 3, for example. Option 3 was to ban non-compete clauses fully. So a pretty radical suggestion to not have them at all. So no restriction as to where someone can work after they leave. Option 4 was to ban non-compete clauses below a salary threshold. So kind of a more moderate version of option 3, really, to permit the use of non-compete clauses only where a person earns over a certain salary. I think in Washington state, it's $93,000 and above, just so you know what happens there. And option 5 was to combine a ban below a salary threshold with a statutory limit. So combining kind of options 1 and 4. There you go. So we'll wait and see what does come out of this. But this has been floating around for such a long time now. Let's see if it actually moves somewhere. So that's pretty much all we know about 2026 at the moment. It's quite a lot, and it could shift, as I said. Keep an eye on that government framework as well, because that, if anything shifts, it comes up in there. So let's talk about 2027 and beyond. Another question for you. How long do you need to be employed to bring a claim of unfair dismissal to an employment tribunal? So, how long do you need to have been an employee to bring a claim of unfair dismissal to an employment tribunal? Is there no minimum service required? Do you have to be employed for 6 months? Do you have to have passed your probationary period, whatever that probationary period might be? Do you have to have 1 year's service, or do you have to have 2 years service? So which of those do you think it is? And there's quite a range there from no service at all to 2 years. Let's see what you think. I'll just pour myself some water while you're thinking about it. I'm hopeful that you'll know this one. So let's see if that's enough time. Right, quite a split here too. So 26% say you don't have any minimum service for an unfair dismissal claim, 8% 6 months, 12% you just need to have passed your probationary period, 9% 1 year, 45% 2 years. I love the way it always says you did not answer the question, but on the earlier poll, it says I'm not allowed to answer the question. But anyway, that's an aside. So here, the majority have it. 45% of you said 2 years, and it is 2 years. If you're bringing a discrimination claim, you don't have to have any minimum service. But if you're bringing a classic unfair dismissal claim, you currently have to have in England and Wales 2 years continuous service. There are some things classified as an automatic unfair dismissal, which you don't need 2 years for, but they relate to breaches of statutory obligations. So, failure on paternity leave, discrimination, as I've said, bringing a whistleblowing complaint. But a bog standard, normal unfair dismissal claim, you need the 2 years. Obviously, if you're pregnant or on maternity leave, you don't need 2 years. If you bring a complaint about health and safety, you don't need 2 years. And they're all called the automatic unfair dismissal issues. Okay, going forward. This is for my interest. If you have contractual probationary periods, so whether you have one yourself or the workplace where you're employed or clients that you work for have probationary periods, how long are they? So I'm just interested in what most people are doing. We don't have any probationary periods. We have a 3-month probationary period, 6 months, or 1 year. So this is the legislation about probationary period. Well, A, there is no legislation about probationary periods, and B, therefore nothing is changing about probationary periods. It's just a contractual issue. So I probably should have had other, in case you don't fall into those 4 categories. But anyway, out of those 4 categories, where do we see them? Let's see what the answers are. Oh, so everybody at least has some sort of probationary period, and it seems to be between the 3 and 6 months. So 51% said 3 months, 49% said 6 months. That's probably what I would have expected, between 3 and 6 months. Good, that's interesting. Thank you. Right, moving on then. So the changes on the 1st of January 2027, the reason for that poll just now is that the cap on unfair dismissal compensation is going to be removed from the 1st of January 2027. And there will be a 6-month unfair dismissal qualifying period from the 1st of January 2027 instead of 2 years. So 2 really big, impactful changes on their way in under a year's time. So the government's original proposal, I don't know if you've followed, if anyone has followed this legislation, the original proposal was to bring in day one rights for unfair dismissal. So meaning that an employee could complain to the tribunal about being unfairly dismissed on day 2 of their employment, for example. There's been a considerable period of, I'm calling it parliamentary ping pong, particularly towards the end of last year. And then the government quietly dropped a little bombshell by adding to their unfair dismissal fact sheet that this is the change that's going to take place. So the cap on unfair dismissal compensation will go. Currently, the cap is either a year's gross pay or £118,000, whichever is the lower. So the cap at the moment is either a year's gross pay or £118,000. That goes entirely. So similar to discrimination claims, it will become unlimited. More importantly, the government says it won't be consulting with unions or employers before it removes the cap, which is wholly contradictory to what they've said all along, but never mind. And secondly, they've confirmed that it will be a 6-month unfair dismissal qualifying period from the 1st of January 2027, not 2 years. They had originally said it was going to be a day one right, but there you go. So 6 months service, and it applies retrospectively. So if you extend a probationary period, if you extended a probationary period and that took someone over 6 months service, they would qualify for unfair dismissal protection, whether they then go on to fail their probationary period or not. So it's the date, not the successful completion of a probationary period that matters. So watch out for that. If the effective date of termination is on or after the 1st of January and someone by that point has 6 months continuous service, they will have the right to bring an unfair dismissal claim to an employment tribunal. And this change is obviously very likely to increase the amount of people that bring claims and the amount of compensation that's awarded, and it will knock off into settlement agreements, because it is an argument for senior staff, and I've used it many a time myself supporting clients. At the end of the day, the most they can get is 118,000. It doesn't matter that they're earning £500,000 a year. The most they can get is 118,000. And of course, that argument goes when you're negotiating a settlement with a high-earning ex-employee. But there you go. It will probably be an incentive for higher paid employees to bring tribunal cases, and it will, remove the current incentive for claimants to make ill-founded discrimination or whistleblowing claims. I think we need to prepare for more on its way. And compensation will still be based on lost earnings. And it should be remembered that just because someone says, I want a lot of money, they don't get a lot of money. It's based on what earnings they've lost. And the average unfair dismissal award is currently 14,000. So it's well below the current cap. But removing the cap is likely to have a significant impact. Remember too that employees in the public sector or private sector that have good defined benefit pension schemes who suffer a substantial pension loss because of an unfair dismissal, they're going to be bringing claims as well, and that will obviously capture those losses too. Dismissals will be more complex, potentially more expensive, I think, for employers. And those high earners, as I've said, will now have more motivation and incentive to pursue an unfair dismissal claim if there's a lot of lost salary and lost bonuses, remember, as well. So I think we're definitely going to see some high value claims added to the tribunal backlog. Also, employees who think they will suffer career-long loss as a result of dismissal, there's an incentive to bring a claim too. So there we go. We can't really predict the impact of this, but I think it goes without saying there will be an impact. Okay, so remember, from July this year, you need to start thinking about induction, recruitment, probationary periods, because it's people employed from July this year that will have 6 months service at the point this becomes law. So if someone isn't going to work out, we need to deal with it within that 6-month period. Think also about your fixed term contracts as well, because this will also impact the use and management of a fixed term contract in employment. You bring someone in on a 12-month fixed term contract and they're not re-employed at the end of that 12-month fixed term contract, that is termed a dismissal. And unless you've got fair reason to not continue to employ them, then they've got the potential, after the legislation changes, to bring an unfair dismissal complaint. So it doesn't just impact permanent employees, it also impacts fixed term contracts as well. And you will also have to provide written reasons for dismissal. At the moment, Someone only has the right to a written reason for their dismissal when they have 2 years qualifying service. That's going to be brought down to 6 months as well. So there's a lot will change, in other words. So watch out for that one and think about its impact on you. And I said that there's lots of different reasons for automatic unfair dismissal anyway, where you don't need 2 years service, and when the law changes where you won't need 6 months service, that is unaltered. These are the kind of reason, if you're dismissed for one of these reasons, it's a day one right to be able to bring an unfair dismissal claim. And I've put a list up on this slide. There are in total about 60 different grounds upon which an employee can claim automatic unfair dismissal and not need any minimum period of employment. Okay, what are the fair reasons for dismissal? Well, the fair reasons are conduct, capability and qualification, redundancy, statutory ban, and SOSR, which stands for some other substantial reason. And as I said when I was answering the question earlier about dismissing someone on long-term sickness, that would fall under that second bullet point of capability. So to dismiss someone fairly, you need the combination of one of the 5 potentially fair reasons plus a fair procedure. All dismissals need to be 2 things: procedurally fair and substantively fair. Procedure has to be followed that's correct, and there has to be good enough reason to dismiss someone. So if you need to terminate anyone's employment, that's your starting point. What's my 5 potentially fair reason? Have I followed a fair process? Is it substantively fair? How is what has happened sufficient to warrant the termination of employment? So once you've established which one of the fair reasons it is, you have to act reasonably before you dismiss. You know, as with conduct, you have to have investigated, you have to have, you know, put matters to the employee so they can respond to them. You have to think whether dismissal is the right outcome. You have to, you know, give that person a chance to say their piece before your mind is made up. There's lots of, which you'll be familiar with because they form your disciplinary policies, lots of steps that you have to take to show fair process and procedure. The ACAS code on discipline and grievances covers off what you should do as an absolute minimum when it comes to conduct and capability, but there's separate guidance on redundancy, and ACAS also explains what statutory bans are and some other substantial reasons. Statutory ban is things like, you know, the loss of a qualification, a doctor that's struck off and can't practice. You know, by some other statute, you're banned from doing your job. And there's some other substantial reasons are it's not one of the other 4 for a start, but it is something that should justify the dismissal of that employee. So the non-renewal of a fixed term contract could be argued as some other substantial reason if it isn't one of the other reasons. Why didn't we renew the fixed term contract? We didn't have any more work for them. Okay, that's a redundancy. If we don't have any work for them, have we got a redundancy policy? If we have we applied it? We're not going to renew their fixed term contract because they weren't actually very good. Well, that's a capability dismissal. Have we followed any underperformance, capability, poor performance process? If so, we need to. Remember, they'll only need 6 months service to bring an unfair dismissal complaint. So make sure you do think about your fixed term contracts as well. Okay, it's 11 o'clock, which is, I want to have another break on the hour, actually bang on for once, or just over. So let's take another 10 minutes. Any questions, please post them and I'll try and answer them when we come back. And then we're in the final section at that point. So let's take another 10 minutes, back at 10 past, and I'll see you shortly. Thank you very much. Hello. Hopefully you're back and you can see and hear me again. Right, 2 really good questions. All questions are really good, but these are particularly good. So the first one is, next year, how do you terminate a 12-month fixed term contract? Surely, if it's fixed term, you can terminate on the grounds that the contract was only contracted for a period of 12 months. Absolutely, it is the most insane is probably not the right thing to say, but it's really curious legislation that we have. So the Employment Rights Act says very clearly that when you end a fixed term contract on its expiry date and fail to renew it on the same or similar terms, that is defined as a dismissal. There's three types of dismissal: where the employee terminates the contract, where the employer terminates the contract with or without notice, and where the fixed term contract is not renewed on the same or similar terms. So it's already in the legislation. The difference is, at the moment, we have 2 years before someone picks up standard unfair dismissal rights. And as I've explained, that's changing to 6 months. So if you want to have a look at what the government says about this, there's go to gov.uk and type in fixed term contracts, or type in your search bar gov.uk fixed term contracts, and it will come up with exactly what I'm telling you. So I promise you this is the truth. So even if you end, or a fixed term contract ends automatically on the planned end date that both parties agreed it would end on, that's still defined as a dismissal if it's not renewed. Most fixed term contractors have no idea that they have that this is the case. You don't have to give notice because the contract has a specified end date, but the Employment Rights Act clearly states that if you fail to renew the contract, then you need to show what fair reason you terminated the employment. So what fair reason you have to not give that person another contract. And we've got 5. Remember what the 5 were: conduct, capability, redundancy, statutory ban, and some other substantial reason. Most of them are probably going to be redundancy or capability. I don't have the work for this fixed term contractor. Well, that redundancy is I don't have the work. That's exactly what that is. Do you have a policy? Have you followed it? Or this person isn't good enough, or I would rather find someone better, or I've got in mind someone different to do the work going forwards. Well, if you're choosing not to give someone another contract because they're not as good as someone else, that's a capability dismissal. So have a look at the gov.uk fixed term contract pages, and it will explain more about this to you. And yes, it could fall under some other substantial reason. You're quite right. Okay, sorry, it is slightly confusing because it just smacks against the whole concept of I've got a fixed term contract and we've both agreed how long it's going to last, and we've both agreed what day is going to end. But there we go. Just have to. I've worked with some employers that have a termination of a fixed term contract policy, and they train their managers in particular how to manage that. But there you go. Have a look. And then the second question, and let me read it out to you, is, sorry if I'm looking sideways, I've got questions in different boxes, is can an employer make a staff member who has brought a grievance against another staff member redundant? And the answer, I'm afraid, is no. You can't make someone redundant because they've raised a grievance. So Section 139 of the Employment Rights Act defines in what circumstances you can make someone redundant. And in very basic language, do go and have a look at it if you want the details. Section 139 of the Employment Rights Act, it says someone could be redundant if the business closes down, if the part of the business that person works in closes down, if there is less work for the number of people, then there can be redundancies, or if there is fewer people needed. So there's only defined reasons that you can class the termination of someone's employment as redundancy. So it's a pretty straightforward answer to that question, I'm afraid. Can I make a staff member who's brought a grievance against another redundant? Answer, no, I'm afraid. Good, thank you for the questions. It's really helpful to know what you're thinking and to be able to help you with those. So moving forwards then, fire and rehire. I've mentioned this concept a few times to you this morning, and this is perhaps the most significant slippage in the new timetable. And it is the provisions designed to restrict the fire and rehire practices, if you like. And these are changes that were going to come into play in October 2026, and now they've been pushed back to sometime in 2027. So the new legislation in the fire rehire arena will make it automatically unfair to dismiss an employee and re-engage them if you're going to impose specific restricted variations to their core terms and conditions, like if you're changing pay, pensions, hours, leave, shift patterns, those kind of things. There will now be a subject to, there'll now be a narrow exemption requiring financial distress. So you can use the fire rehire process if your employer is in financial distress. So it doesn't mean that you can't vary employees' terms and conditions and vary their contract, because we can still negotiate, we can still reach agreement, we can still do all of those things. What it does do is it says if an employee refuses to agree to a change where this is a restricted variation, then the final step that an employer can currently take of dismissing and re-engaging, firing and rehiring becomes a very high risk exercise. You'd have to have that evidence, strong evidence of financial distress. Okay. Before I go, what else in 2027? Sorry, just an update on the question about the redundancy in the grievance. And the question is if the grievance will, I'm just wondering, sorry. So extension to that question, if the person raising a grievance, does that mean it will block or postpone the redundancy? Good question. So if someone is at risk of redundancy and they raise a grievance, should that block or postpone the redundancy? And a lot of employers would put the redundancy process on hold and deal with the grievance if the grievance relates in any way to the selection or the redundancy process. If the grievance is unrelated, I would manage the two in parallel. We continue with the redundancy process, we'll hear your grievance. But if the grievance is somehow about the redundancy decision selection process, then it might be sensible to pause, deal with the grievance and continue. Hopefully that helps. Sorry, thank you for the update on that question. So what else in 2027? Well, according to the UK Government Employment Rights Act roadmap, there are more measures and consultations in 2027 that I've already told you about, and they are on this slide. Again, I'm sorry, it's a bit of a busy slide, but it's really just there for you to be able to read afterwards. I'm not going to go into much detail on these because we need more information and they don't have start dates yet. So, I'm just putting it out there into the universe. And then when we come back again in a year's time, hopefully we'll have a much more clarity, much clearer idea of what's happening and when. So I spoke to you already about the menopause action plans, so they will become mandatory for large employers. We've got this new legislation likely about it being unlawful to dismiss a woman while pregnant on maternity leave and with 6 months of returning to work with some exceptions. So something may come along there. The introduction of a power to enable regulations to specify steps regarded as all reasonable steps to prevent sexual harassment. So we're expecting something more on that. As I told you, the obligation will come in before we get the regulations, possibly. Strengthening protection against blacklisting. This is another trade union issue. Introducing a new industrial relations framework. Regulation of umbrella companies brought within the Employment Agencies Act framework, if you're involved in agencies at all. Collective redundancy, altering the collective consultation threshold, making flexible working a default day one right, apart from where it's not reasonably feasible. So we already have flexible working as a day one right, but this will make it automatic unless not reasonably feasible. Hoping that one doesn't come in or doesn't come in without some sort of exceptions. Introduction of a day one right to at least 1 week of bereavement leave for all employees. Zero hours and low hour workers will have a right to guaranteed hours, or a contract that specified their guaranteed hours, which reflects the hours that they regularly work. Also, they will become entitled to reasonable notice of shifts and compensation for short notice cancellation of work. So quite a bit of change for 0 hours and low hours workers. And then electronic and workplace balloting for recognition and de-recognition ballots. So as I said, exact dates for these will follow. Secondary legislation is likely. It could align with we're used to April and October being the most likely commencement cycles, but we've also seen things in August, February, December. So there we go. That's a few of the predictions for all other matters in 2027. I did mention to you the Equality, Race and Disability Bill. So most of what we've talked about so far is all within this one new massive bit of legislation. This would be separate. And you're probably familiar, or you will at least have heard about the gender pay gap. But this is the government announcing that they're looking to introduce a separate race and disability legislation that will deal with ethnicity and disability pay gap reporting and the extension of equal pay rights to ethnic minority and disabled people. Again, this will be for large employers, which is what the gender pay gap is. So that's employers with 250 plus people. And the draft bill, I don't think has yet been published, but we expect it sometime this year. It may also bring in something called dual discrimination, which is where somebody has a discrimination complaint under 2 or more protected characteristics. So I feel less favourably treated as a disabled woman, for example, or as a black, man, or whatever it might be. So it may bring in dual discrimination and make that unlawful, and set up new pay transparency measures, a new equal pay regulation and enforcement, and so on. So lots of potential new obligations that relate to race and disability primarily. But I think the Act will also impose an obligation to keep records demonstrating you've complied for 6 years or more. And the failure to comply with that could be a criminal offence with potentially unlimited fines. So lots to look at if that legislation comes in 2027. And here's the summary of what the bill could cover. Again, have a read at your leisure. Of course, we don't know exactly what it will be or when it will be at this point. Okay, I said we would talk about the statutory calculations, and they are next. Where we don't yet have figures for 2026, I will let you know. Actually, I've just seen another question come in. Excuse me, before I start on this section. Employees working from home, can the employer force the employee to work in the office or from home or vice versa? It's funny because that exact issue we covered in quite a lot of detail last year. And there are circumstances when you can, but the issue we have to look at now is how long has someone been able to work from home instead of in the office? And is there any difficulty or not? Is there good reason to bring them back? What has the contract said? Have we consulted and discussed it with that person? And so on. Is there any disability or discrimination issue that might mean that person can no longer, work in the office or whatever it could be? So yes, the answer is in some circumstances, if the contract states the place of work is in the office, we can force people back to work, but it comes with a but, and there could be other circumstances that you need to take into account. So yes, but is probably the answer to can we force people that work from home to work in the office? Good. Right. Statutory calculations are next. And as I said, where we don't have figures, I will tell you. So the government has announced its acceptance to the Low Pay Commission's recommendations on the national minimum wage rates for 2026. These apply from the 1st of April this year. And I've put them up on the screen for you. So, main one, £12.21, increases to £12.71. Okay. Moving on, our family-friendly statutory payments for 2025 have gone up, or will go up rather, on the 6th of April to £194.32. So this will be the rate for statutory maternity pay, statutory paternity pay, statutory adoption pay, statutory neonatal care pay, statutory shared parental pay, statutory parental bereavement pay. So we've got quite a few now in the statutory arena, and the rate is the same for all of them. Again, go to gov.uk to see where they all apply. Okay, then SSP, I've mentioned the changes that we're going to see, but the rate also changes every year too. So on the 1st of April, it goes up to £123.25. Statutory redundancy pay was £719, and we still don't have the 2026 figures. I meant to have a look this morning just in case they're in, and didn't. So that will come soon in due course, but at the moment, or at least when the slides went off for publication, we didn't have the new figures. Okay, then the real living wage, £13.45 out of London, £14.80 in London. So the living wage rates for 2025-26 were announced back in October, and then employers have 6 months to implement them if applicable. So that would be May 1st, 2026. 2025, the maximum compensatory award at the tribunal was the lesser of either 52 weeks gross pay or 118,223. Again, we don't have the 2026 rates yet. It will be sad to move away from an easy number to remember. It's, I guess, easy-ish number to remember. And the cap, don't forget, the cap is going in January 2027 in any event. Then the Vento bands, these usually go up every year. I haven't seen this year's yet, so I've given you the 6th of April 2025 rates. The Vento bands are how much people are awarded in an injury to feelings claim. And injury to feelings come with discrimination claims at the employment tribunal. So if I say I've been discriminated against on the grounds of my disability, I seek compensation, I get loss of earnings applicable. You know, if I had to lose my job and it took me 6 months to get another job, then I've got the potential for that loss of earnings to be paid to me. Alongside that, I've got what's called an injury to feelings payment. And these Vento bands are how a tribunal decides how much to award somebody. So lower for less serious cases, higher for more serious cases. Okay, hopefully that explains what they are. Oh, I've told you all these already. I must put it in twice. So there you go. Those are the statutory limits for you on various payments. Hopefully, if you're looking out for those last two that haven't yet been announced, please just keep an eye on it. It'll be in the press at some point anyway. And then our last section is cases of interest. So I know I gave you a few this morning, but they normally are the ones that catch my eye for sometimes the weirdness of them, even though there's always good learning points. These are a bit more general. Let's have a look at a few. So the first one is with Barclays Bank PLC. When it comes to harassment, I think this recent Barclays case demonstrates the line between, you know, good process and not good enough process can sometimes be quite a thin one. And sometimes people get too involved when they're conducting investigations on proving guilt rather than finding truth. And I do loads of workplace investigations for employers, normally where they're either senior people involved or they're very high level, or they could be, you know, potentially very expensive litigation, and they need an external person to come in and have that external perspective. my investigation isn't about proving guilt, it's about finding truth. And that should be the same with all investigations. And also this zero tolerance issue. You know, if we say we have zero tolerance, we need to demonstrate that. And this claimant had been with Barclays Bank for about 9 years. They were a financial guide in the mortgage team, experienced, long-standing employee, clean disciplinary record. But that stability came to a bit of an abrupt end when a younger female colleague made a complaint that he had made sexually inappropriate marks to her. And she alleged that he asked her, and excuse my repeating exactly what was said, was, "If I show you my willy, will that make us friends?" Which I just sometimes sigh about what people think is a good thing to say at work. And then other things followed, like, why don't you buy yourself sexy underwear? What's the youngest a 40-year-old should sleep with? And questions like that. Anyway, complaint is made, an investigation starts, and of the allegations, he only admitted the last one about the youngest a 40-year-old should go with, and said it had been a clumsy conversational question on a different context or whatever. The rest of the allegations were denied outright. No witnesses, nothing in writing, no messages. So how do you decide? Well, he was suspended on full pay and an investigation followed. Complainant interviewed, which is normal. Whoever alleges the issue, speak to them first. Investigate, speak to the accused, which they did. No one corroborates the specific remarks. One person noted that he could sometimes be a bit close to the line in his humour, but it wasn't overtly sexual. And the investigator concluded that it was likely that all three comments had been made, and that assessment became the foundation of the disciplinary process, although the scope of allegations did grow as part of the disciplinary issue. Anyway, he goes to a disciplinary hearing. His letter of invitation lists not just the 3 allegations, but 5, so 2 that had never been put to him and had never been investigated, which is a bizarre thing to do. Although the person who chaired the disciplinary meeting did say that the hearing would only focus on the 3 he had been advised about. Weirdly, though, having done all of that, the dismissal letter dismisses him for all 5. It's always interesting when an organisation like Barclays Bank make a mess of something. Anyway, the process also took more than 4 months from hearing to outcome, so a very long time. And when the decision finally came, he was dismissed for gross misconduct because his behaviour was incompatible with the zero tolerance policy. He appealed, and the appeal officer reviewed everything and spoke again to the complainant. The original decision was upheld. So what did the tribunal say? Well, the tribunal said that he had been dismissed for conduct, which is a potentially fair reason. So the issue was not related to why he was dismissed, but how. And the tribunal found that the investigation and the disciplinary process were seriously flawed, and therefore fell outside of what might be a reasonable process, an expected reasonable process. So it was an unfair dismissal. And the reasons it was unfair were numerous. The investigation was one-sided. It was intent on proving guilt, not finding fact. The investigator sought evidence of past behaviour, but didn't seek to find evidence of whether it was accurate or not, or whether he had been misunderstood or misremembered because it was very old. That there was the disciplinary chair had included matters that should not have been included. The letter of invite was incorrect. The dismissal letter dismissed him for things that he'd never had a chance to speak about, and so on. The delay of 4 months when he was promised it would take no more than 2. So lots of reasons that should never have happened. It was an unfair dismissal. So I think process can't be underestimated. That is my takeaway from this. Tell people what they're accused of, evidence it fairly, proper investigations that aren't witch hunts, good disciplinary hearings and meetings where people have a chance to know what they're facing and have a chance to defend it, and then think carefully on what reason you're going to dismiss someone. So I think, powerful message that you've got to get the process right. He was not vindicated in full, though, because the tribunal found that he had contributed to his own dismissal, but only by 15%, because he admitted to at least one of those comments. So although he won, he lost 15% because of that one comment. But there you go. I stress to managers all the time. I do lots of training for line managers called Managing People Lawfully and Effectively, MPLE. And I always say to people, if you get your investigations right, and you can show procedural and substantive fairness, you are nearly home. So investigations really important. And for me, it's striking how many of those failings in that case were entirely unavoidable. I won't go over them again because I've spoken to you about them. My next one is an EasyJet case. I think we normally have an EasyJet case every year, actually. This one is all about flirty banter. When does flirty banter cross the line? I expect many of you have worked in places where there's been some workplace banter. I do hate the phrase, but there you go. But the line between friendly and inappropriate can be crossed pretty quickly, and more quickly than probably people expect. And that's what happened in this case. Mr. Barr was a heterosexual man, and he brought a claim for unfair dismissal and sexual orientation discrimination. And he claimed that he'd been discriminated against because he could not make the same comments as a gay colleague would be able to make. So basically, he said, if a gay man said these things, they would not be accused of harassment. But as I have said them, and I am, that's less favourable treatment because I'm not a gay man. So the allegations included things like telling a colleague that he was going to stare at her backside instead of work, calling female flight attendants over the tannoy lovely ladies, making sexual references to the more attractive colleagues, brushing past a colleague and saying, "Oh dear, did I just brush your boobs?" On another occasion, it was said he spent his whole shift pretty much making jokes about sex. He said to one colleague where she was putting an extension seat belt back into the bag, "I bet you've never had a problem trying to stuff it in." Just this kind of thing. I hope you get a drift without me having to list them all. But there were complaints from both fellow cabin crew and indeed passengers who overheard some of this banter, comments and behaviour, and he was accused of inappropriate and sexually suggestive behaviour. He defended it all as just flirty banter. But there you go. It led to his dismissal for gross misconduct. And back in August, the Employment Tribunal upheld EasyJet's decision and said dismissal was a reasonable response. So clear takeaway, I think. It's another good reminder that whether you intend a comment to be light-hearted or not, it can amount to harassment. It's how the person feels, not how you intend them to feel, that matters. And that leaders should always, be that role model, be the respectful professional, set the tone for the rest of the workforce, and making sure that people understand what's acceptable and what isn't. Because this went on for a long time. Lots of colleagues hearing this kind of behaviour for a long time. And it was allowed to continue until someone finally raised a complaint. But it's very arguable that it shouldn't have continued that long. I can't really talk about discrimination without mentioning this case, because this was big news. The Supreme Court decision in April 2025 reached its judgment in For Women Scotland Limited versus Scottish Ministers. And this was where they confirmed that the word sex in the Equality Act means biological sex. And the EHRC issued an interim update saying that employers were required to provide sufficient single-sex toilets and, where necessary, single-sex changing and washing facilities, and that trans women, biological males, should be excluded from women's facilities and vice versa. The regulator has since slightly revised that wording, removing the sentence that single-sex toilets are compulsory, and in its place it now says that organisations should provide suitable and sufficient facilities, and that toilets, showers and changing rooms can be mixed sex, provided each cubicle or room is lockable from the inside. And obviously there can't be any urinals in mixed sex facilities. But there you go. That was a big case showing that sex means biological sex. Okay, here's a poll for you. Here's a question. What is the approved code of practice minimum temperature to work indoors? And I've got 5 options for you. So is it that there isn't one? Is it 10 degrees? Is it 15? Is it a range, 13 to 16? Or is it 20? So what do you think of those? And let's see what you think. So 35% of you say there is no minimum, 4% 10, 11% 15, 37 13 to 16, and 14% say 20. Well, the majority have it again, just the 37% of you that said 13 to 16 degrees are correct. I think the majority has got it every time this time, so that's good. This is the workplace health, safety and welfare regulations, and they require employers to provide a reasonable indoor temperature in the workplace. It depends on the work activity and the environmental conditions. There's also the construction, design and management regulations. Have a look at the Health and Safety Executive website if you want to know more about this. But it says that temperature in the workplace is one of the risks that should be addressed and assessed. And the approved code of practice says indoors should be at least 16 degrees or 13 degrees if much of the work involves rigorous physical effort. So it is a little bit dependent. And why have I asked you this question? Well, we've had a case with the Whipped Cafe in Covent Garden. What a great name. How cold is too cold to work? And at what point does it become, more than just uncomfortable? And that was at the heart of this case. This claimant worked as a part-time shop assistant and raised concerns about having to work in very cold conditions because the cafe had a rule that the main door must always stay open to attract in passing customers. And that meant that the indoor temperature often dropped as low as 12 degrees. She asked for a heater, she asked for the door to be closed, and it was refused. And in a WhatsApp message, she explained that she was wearing 3 layers of clothes and thermal underwear to stay warm, and pointed out that the government guidelines request or suggest that there should be a higher temperature. Anyway, a few months later, she's dismissed, gets no pay or notice. It's alleged it's poor timekeeping attitude. She has a different view. She brings an employment tribunal claim and says, I've been dismissed for whistleblowing because raising a health and safety issue that affects more than one person is a protected disclosure under the whistleblowing legislation. And she said it was a legitimate health and safety concern. And what they say I've done wrong, I haven't done wrong. And I think it's because of this WhatsApp message. And the tribunal agreed, and she was awarded over £21,500 in compensation. So often we don't spot what is a whistleblowing issue. And I've had clients say to me over the years, oh, so-and-so was complaining about X, Y, and Z. So when we decided whether we were going to, keep them on at the end of their probationary period, we didn't. And when I go back and look at, well, what is it that they were moaning about? I can see that they raised a whistleblowing issue. That means they didn't need 2 years continuous service. Remember, that's going down to 6 months. And therefore, that person still has the ability to raise a claim. Because what often employers think is they don't have 2 years, they won't be able to bring a claim. And if it's whistleblowing, they can. You don't need any minimum service. But there you go. How cold is too cold to work? Well, in this case, it was 12 degrees was too cold to work. This is a case, AB versus Grafters Group, where the claimant worked for this organisation in the hospitality sector. She believed it was a hospitality agency. She believed she was booked to do a shift at Hereford Racecourse. She arrived late to the agency office, missed the free transport the employer had arranged to get the workers to Hereford. So a male colleague gave her a lift. Um, anyway, she was told that she actually wasn't required to work that day anymore. And this person gave her a lift home. And in driving and taking her for a lift, he inappropriately touched her, showed her pornographic images, asked her sexual questions. And this is, I'm quoting from this case, tried to put his finger in her mouth and ear and tried to kiss her and so on. And the question for the tribunal was, is this in the course of your employment? So at the point she got in the car, she was told she wouldn't be working. So can this ever be seen as something that took place as harassment done in the course of someone's employment? And the tribunal found that it did. But it was found that on appeal at the EAT. And they said that, it is clearly within the extension of employment. It's outside of working hours. It's not part of someone's duties, but is there sufficient connection with employment to bring it within the course of employment? And the Employment Appeal Tribunal found that it had. So often people will say, well, what happens outside of work? Why should that be our problem or our issue? And it so often still is if it's got that connection to employment. I think most people understand the Christmas do is in the course of your employment. But I've had people argue, but if a few people go for a drink after the Christmas do, surely that connection is then lost. But the answer is no, it's not. So think about what action you need to take, even if it appears to be not part of someone's job during working hours, directly connected. Is there a sufficient connection? And there was in this case. I think I'm going to have to add to my discrimination training, don't insert your fingers into someone's mouth or ear, which is a very sad thing to have to do, but there you go. Then we've got Zen Internet versus Stobart. There are key lessons here on capability and Polkey. For those of you not familiar, the Polkey principle is a great argument employers run that say, well, you might have found that I have been procedurally wrong in some way. There are some procedural failings in what we did, but had we have done it right, the outcome would have been the same. We would still have dismissed that person. So what it does often is say, okay, well, let's give someone, excuse me, another 3 weeks pay because you didn't have a proper process. And had you had a proper process, it would have taken 3 weeks, but the outcome would still have been dismissal. So it's a really helpful argument, the Polkey principle. And in this case, Mr. Stobart was the CEO of this company, and he was dismissed for capability without any process being run. And often people think senior employees, there's no need to run a process. But of course, everybody has the same protection. And a tribunal held the dismissal was procedurally unfair. I don't think there's any surprise there. You can't just dismiss someone for poor performance without any process. But they did find that there were good grounds for the outcome to have still been dismissal. And the tribunal found that a fair process would have been completed, but probably would have taken 2 months. And therefore compensation was capped to reflect that window. An appeal went in. The Employment Appeal Tribunal upheld the employer's appeal in part, and there were some, tricky things about Polkey. But what I've raised it here for is that very important point that if you're in a position where you have to defend a case and you can show whatever your procedural failings were, had they have been done perfectly, the outcome would have been the same. Then think about that Polkey argument. Also remember, a really good appeal can correct some earlier procedural failings. So if somebody messed up a bit, the disciplinary process, have a banging good appeal, and then you can demonstrate that you've put right those failings by having a really good appeal. This is a case about alternative employment in a redundancy situation. And this claimant, Mr. Kennedy, had worked for this car dealership for a long time, more than a decade, I think. And his post was put at risk of redundancy. He accepted that the redundancy situation was genuine and that his selection was genuine, so sees no fault in being at risk of redundancy. The whole of this complaint was about what happened in his 7-week notice period, because what the employer did was said, have a look at our public vacancies and let us know if there's anything you want to apply for. However, by that point, they'd reclaimed his laptop, they've taken his access from the internal intranet, and they failed to tell any of the recruiting managers internally that this person was at risk of redundancy and during their notice period was trying to find internal alternative employment. And therefore, obviously, he didn't get a position. And the Employment Tribunal held that this total lack of proactive assistance and, in fact, blocking him from being able to make applications made the dismissal unfair and gave him his full loss with no Polkey reduction. So even though they might have said, well, had he have applied for this job or that job, he wouldn't have got them, the tribunal said, no, there'll be no Polkey reduction in this case. So when someone's at risk of redundancy, we need to be proactive in trying to find them alternative employment internally. And it should be a two-tier process. You look at internal candidates for vacancies before you advertise vacancies externally. So exhaust any internal candidates and find them not suitable before you consider advertising externally. You shouldn't pitch internal candidates against external candidates for a role in a redundancy situation. Okay, I think we've got time for a couple more. Sex discrimination is what this case is about. A healthcare support worker was discriminated against on the grounds of sex when her employer failed to provide her with a lockable room to express breast milk when she returned to work from maternity leave. And they didn't fail to do it once, they failed to do it on 2 returns from 2 different maternity leaves. When they eventually fitted the lock, it cost them £5.50. This was a very expensive mistake to make. There's no legislation that says you have to give women that want to express milk at work a lockable room, but this employer had said they would, because people kept walking in and out of the room that they allocated her to use, and she wanted privacy. So be, very mindful of what you say you will do. If you say you're going to do something, it's really important to then do it. But consulting with people, finding, if you haven't got a room that's lockable or you don't want to put a lock on a room, then how else do you give someone that suitable privacy to express milk in this circumstance? Have a look at the Health and Safety Executive website for what your responsibilities are for breastfeeding mothers that return to work. But this was a case where the failure to provide this locked room caused her to win her sex discrimination case. This is Anne-Marie Alexis, who's employed as a receptionist administrator by the Westminster Drug Project. Again, she had, I think, about 10 years service, long-standing, and a restructuring process reduced 3 roles into 2. And despite her having disclosed her dyslexia, when she was being assessed for that changed role, she was given some additional time for the assessments, but she was only provided with the interview questions 25 minutes in advance of the interview, which she said gave the result of her underperformance. And she was told she wasn't selected for either of the roles available. She raised a grievance about the process. They offered a re-interview with adjusted conditions, and that was still found to be unsatisfactory. She continued to express her dissatisfaction. It led to extensive correspondence about the process. She raised more grievances and complaints, and in the end, they dismissed her for some other substantial reason, saying there's a fundamental breakdown in the relationship and trust and confidence has gone. She claimed unfair dismissal, disability-related harassment, failure to make a reasonable adjustment, and the tribunal rejected most of those claims, finding that her dismissal was fair. She appealed to the EAT, arguing that they hadn't looked at her length of service correctly, or alternatives to dismissal, such as a warning. And the EAT dismissed her appeal, upholding the Employment Tribunal's decision. So they said there had been a breakdown of trust in relation to how she behaved and continued to behave through and after the grievance process. In other words, she just wouldn't accept the outcome of the grievance and continued to raise the same or similar cases. And the tribunal and the EAT both said that her behaviour in doing that led to a breakdown of trust, and it was reasonable for her to be dismissed for that. And this is a really important case because some employees who raise grievances do not accept the outcome, even though the process is finished and the appeal is finished. And even long-standing employees can face dismissal if how they continue to behave after a matter has been concluded undermines the foundation of that ongoing employment relationship. So really important case for employers, I think, on that one. I think I'll make this the last one. I think there's only a couple more afterwards in any event. So Miss Rook brought a claim against the NHS Blood and Transport organisation, NHS, it's called the NHSBT. She alleged constructive unfair dismissal and disability discrimination that was related to her diagnosis with anxiety, and said they had failed to make reasonable adjustments and had failed her when she blew the whistle. So lots of different claims in this one. But the Employment Tribunal dismissed her claims for unfair dismissal, for disability discrimination, and for the failure to make adjustments. However, they upheld her whistleblowing detriment claim. This is why we've got to spot whistleblowing issues at work. And she raised three concerns, which all related to donor safety checks and training standards. So she raised three whistleblowing issues, which were for good reason. And she believed they all posed a health and safety risk. And then at some point later, she has some time off for stress. She has, unfortunately, a mother with dementia, and she takes some time out of work. And in the end, she submitted a resignation, which she later attempted to withdraw, but they refused to allow her to. She said, I didn't mean to resign, I'm under stress. And they said, hard luck. They might have not have said hard luck, but they refused to allow her to withdraw her resignation. Anyway, so why is there a picture of Darth Vader here? Well, a striking part of this case involved a team building event where a personality assessment, a Myers-Briggs type personality assessment, was carried out. But rather than having more normal responses as part of that personality assessment, she was, in her absence, marked by a colleague who put in their own input and said that she'd come out as a Darth Vader type personality, which obviously is the fictional villain from the Star Wars franchise. So this colleague of hers, in her absence, she's off sick with stress, does the personality assessment on a team building event on her behalf and announces to everyone she's Darth Vader. So she finds out about that and is very upset about it. She says it relates to her whistleblowing detriment. And the reason it relates is the person that did the assessment on her behalf was one of the people that she had complained about. There you go. She ended up £30,000 better off as a victimisation of a whistleblowing detriment. So I don't know quite what the learning point should be here. Obviously, there should be, care taken on training courses, especially when people are absent, not to cause them any upset. But here she was also able to link that back to the person that did the assessment was also one of the people I'd complained about. So that brings us to the end. We're out of time. There's only a couple of other cases that I was going to mention to you, but you'll see their names from the slides, and do take a look if you want to. Thank you so much. Lots of questions, which has been really good. I don't think I've missed any. Let me have a quick look. Someone saying that they worked in a food supermarket, was utterly freezing, and I had 9 sets of thermals on. Well, goodness me, that sounds awful. But thank you all very much indeed. Have a great day, lovely weekend, and hopefully I'll see you again.